Hello, everyone, and a very warm welcome. I'm delighted to have you join us for today's Lexology Masterclass in collaboration with Mason. It is magnificent to see our audience tuning in, and we do have a really insightful session lined up for you today with our speakers Rohit, Stephen, Mark, and Niall, sharing practical perspectives, insights, and key takeaways that we hope you'll find beneficial in your work. Before we begin, just a few quick housekeeping points. Please do use the Q&A tool to submit any questions you have throughout the session, and our speakers will hopefully address them. And if you experience any technical difficulties, use that same Q&A tool, and a member of the admin team will be happy to assist you. And finally, just another reminder that today's session is being recorded. We'll share the recording with you via email in the coming days so that you can revisit or share them with your team. That's everything from me. Without further ado, I'm pleased to hand it over to our speaker, Rohit, to get us started.
Good morning, good afternoon, good evening, everyone. It's my pleasure to be here moderating this wonderful session, which is quite apt in today's world. My name is Rohit Singhal, and I am from Mason, and I'll be the moderator for this session. Uh, we have a wonderful panel, consisting of the right experts to talk about the issue of disputes which are associated with the long-term gas pricing, LNG pricing agreements and contracts. So before I get into the details of the topic, let me just introduce my co-panelists. So I've got Stephen Finizio. He is a partner at Wilmer Hill, London office, and Stephen is a leading international disputes lawyer and arbitrator with extensive experience in energy, financial services, shareholder and joint venture disputes. He has dealt with number of such kind of gas pricing disputes as well, and advises clients across various jurisdictions, including Europe, Asia, Latin America, and America, etc. He does a lot of pro bono work as well related to and has got an extensive amount of experience in arbitrations and does a lot of contribution to the arbitration laws and other areas associated with arbitration. Then I'm glad to introduce Mark Mangan. Mark is a partner at Lindsay, Francis and Mangan. Mark is a leading arbitration lawyer with experience as counsel and arbitrator in over 100 international arbitration cases. He has acted as counsel and lead lawyer in landmark LNG price review arbitrations, gas pricing disputes, and renewable energy matters across Asia Pacific and globally. Mark is a member of the ICC International Court of Arbitration, co-author of leading arbitration publications, and a recognized thought leader by Lexology. Welcome, Mark. And then I have got Mr. Niall Trimble, who is our gas pricing expert, who's going to talk about and give a perspective about the expert views on gas pricing, long-term contracts, and the disputes associated with that. Niall has been advising clients on gas and LNG sales, purchases, and disputes for a number of years. He has an extensive experience in long-term gas pricing contracts across Europe, Asia, and Australia, and has played a key role in the sales of significant volume of UK gas production. He also advises LNG and hydrogen projects globally and regularly serves as an expert witness in energy disputes. So thank you everyone for joining this webinar, and I think it's going to be interesting discussion. Now, before I get into asking questions to my co-panelist, just few thoughts about the long-term gas pricing contracts and LNG pricing contracts. The original intention, when these contracts were entered by the parties, both seller as well as buyer, was to have some kind of a stability in such kind of purchase and sales of gas and LNG as hydrocarbons. They were designed to do one particular thing, which was to provide certainty. Now, unfortunately, because of the geopolitical situations which we have seen in last couple of years, and recent one which related to the Strait of Hormuz, these gas pricing contracts and LNG pricing long-term contracts have become uh, one of the most litigation-prone long-term contracts, and you see a lot of disputes which are nowadays seen in arbitration in such kind of contracts. The certainty, which was the word, which was the key word, wherein the buyers and seller were looking for certainty of supply, certainty of revenue, has gone for a big toss. And then the pricing formulas, which were the core for such kind of long-term contracts, which used to be indexed to either crude oil or refined products, which were a mechanism to share a risk in the market, are the ones which are now under serious challenge. And what is happening nowadays, that in case there is a small change in gas pricing associated with the gas pricing formulas which are there, you would still not see that much dispute one. But what happened recently with the Strait of Hormuz related issues, there were a huge changes in the gas pricing. The pricing formulas which were there in such kind of contracts were no longer valid, and that's where a dispute comes into picture, and that's the bone of contention between the seller and the buyer. And today the topic is quite apt, and we are going to talk to our experts and explore areas associated with such kind of disputes. So now, not taking much of time and straight away jumping to the real questions which are going to be discussed as part of this webinar. I'll start with you, Mark. You have been dealing with such kind of long-term pricing contracts for quite some time and have been involved in a number of disputes and arbitrations related to that. So, in your view, uh, what separates a well-drafted price review trigger from one that invites litigation in such kind of contracts? Over to you, Mark. Thank you.
Thank you, Rohit, and to your colleagues at Masson for including me in today's webinar. I'm delighted to be here. So to answer your question with one word, that is clarity. That's what separates a well-drafted price review clause generally, and including in relation to the trigger requirements, from one that invites litigation. And the clarity that I refer to relates to when you can trigger the price review, the procedure to be followed in the price review, the criteria that can be considered when determining whether or not an adjustment to the price is required, and importantly, the rights of the parties if no agreement is reached within a specified time. You would think perhaps that all of that was obvious, but for those that are new to the area, they might be surprised to learn that some of those things are not particularly clear in long-term LNG price review clauses. And in particular, that last one, whether or not a party has a right to do anything if an agreement is not reached. Earlier generation price review clause that are still in operation in the Asia Pacific are often silent as to what can happen if an agreement is not reached. And that invites litigation, or more specifically, arbitration, as to whether or not a party has the right to elevate a failure to agree to a tribunal. And there have been a number of cases that have where that question has been considered, whether a tribunal has the jurisdiction to adjust the price if the parties have not reached an agreement. So in order to avoid those types of disputes, then drafters of these price review clauses should aim for clarity. But it's not easy because they need to get the right balance. Rohit, in your opening remarks, you referred to certainty. They need to provide a degree of certainty within the price review clause to help narrow the debate and focus the minds of the negotiators in a future price review. But at the same time, they need flexibility within the language of the price review clause, because they need to adapt or apply that price review clause in an uncertain future over a 10, 15, 20-year period. And you referred also to recent events in the Strait of Hormuz. Those events may not have been forecast or predicted at the time of some of these contracts being negotiated, and so that can then create a problem in the future if the language within the price review clause is overly specific and overly certain and not sufficiently broad and flexible to account for so-called black swan events. So I'm conscious that we have lots to get through, but in a nutshell, clarity and a good balance between flexibility and certainty.
Thank you very much, Mark. Steve, your views, please, on the
Yeah,
issue
and
of
look,
triggers
Rod,
mechanism.
thank you for inviting me. And I've been doing price reviews in the Atlantic Basin, Europe, and Asia for 25 years. And I actually am going to raise a slight point of disagreement with you. I think we've already hit a point where in Europe in particular, we had an explosion. We've had waves of price reviews, and it's become the norm that every time there was a scheduled price review, the parties would initiate a price review process. So I don't think recent events will have increased the tendency to litigate these provisions. I think that has started to happen in Asia before the war. We'll see whether the recent events increase it. I think it was going to increase anyway, and what's going to happen is that recent events will be potentially a reason to put into a price review request or to defend an upward adjustment, for example, requested by a seller. But I think in terms of what a well-drafted clause does is I think these clauses A are not well-drafted. Even even the best ones are not well-drafted. Mark's right, clarity is useful, and I think Mark's also right that one of the things, particularly in Asia, we see that's confusing is what happens if a price review is requested and the parties don't reach agreement, and therefore what the process will be. That's changing, but I think that's an area where going forward it would be good to have more clarity. I think the real answer is what do the parties want? Because even the most tightly drafted clauses are down to what the parties decide to do with it. And vague clauses and well-drafted clauses will both whether we get litigation and what the litigation is, or it's always arbitration or expert determination, depends on the parties' commercial interests. And that commercial interest moves around a lot. But these are all relationships. These contracts are all taking place over the course of 10, 20, 30, 40, 50 years in an ongoing daily relationship, right? So they have to manage that within that relationship. And as you said, a small change in pricing can have massive consequences for a contract. So in the old days where the buyer could pass on the price increases downstream, they didn't care so much. Now they care tremendously because of competition. You had said they were built for certainty and stability. I think that's true, but we have to take that apart a little bit. They were built to guarantee on the seller's side the sort of income through these take or pay contracts that would justify the financial investments required to build these large scale projects, whether it was the liquefaction facilities or whether it was pipelines. But from the seller's side, you wanted that long term financial security. And from the buyer side, particularly when you're in monopoly markets, it was to guarantee that you had the security of supply. Um, Interestingly, 5 years ago, in price reviews in Europe, sellers were saying and buyers were arguing about whether there was any value anymore to security of supply. Now, between the Russian war and the Gulf War, and maybe the pandemic as well, suddenly security of supply has the value of that has become more apparent again. So I think as we were shifting towards shorter term contracts, I think longer term contracts are going to be seen as more valuable going forward again, and the security of supply and the certainty as part of that is critical. But stability and certainty also has to deal with the fact that in a 20, 30, 40, 50-year contract, the drivers for price and value of LNG are going to change. And that's why we have price review clauses. We have price review clauses because the parties need a mechanism to allow them to adjust the price and to try to keep the value where they thought it was when they made the bargain. And that inherently means there's going to be a use of these clauses, no matter how well drafted, that is fundamentally commercial and fundamentally about what this mechanism provides in terms of the ability to adjust the price either by agreement or through an arbitral tribunal or an expert determination in order to try to keep the economic balance in place. And therefore, how well or badly drafted the trigger clauses are second to me to what the economic circumstances are and what the parties will to either reach agreement or the need because of maybe other pressures, bureaucratic pressures to fight a request. And it doesn't matter to me how well drafted the clauses are, other than Mark's point that it's good to have clarity about what the process will be if you go to a formal price review.
Could I just add a point here,
Yes.
Rohit? The question implies that if the trigger is well drafted, there'll be no litigation. I have to say that's not necessarily true. It depends, as Stephen quite rightly pointed out, on the economic interests of the parties. If you're a buyer and you're facing a loss of $500 million over the next 3 years, you may go for it, even if it looks like you might not win and the drafting is not helpful to you, simply because there's so much at stake.
Right.
No, thank you, Steve and Niall, for this. So, Niall, since you just pointed out about your views on the trigger mechanism and all, You are an expert, and you have appeared as an expert in many matters related to such kind of trigger-related aspects. So when a review is done and a review is triggered, how you as an expert actually reconstruct the fair or the market reflective price when you act as an expert in arbitrations or in case you are advising your clients?
There's a fairly well established methodology for this in Europe, which probably applies in Asia as well. You use a net back process. In order to get to the market value of the gas or the LNG as opposed to the contract price at any one particular time, you take the average price paid by all the customers in the market, so all of them, power generators, industrial customers, domestic customers, take the weighted average of that. You deduct from that the costs that the buyer of gas faces in getting it to final markets, which is basically gas pipeline costs, storage costs, things like that. Then you make a deduction for the overheads of the buyer and a reasonable margin for profit, which is typically around 2, 3, 4% or something like that. Whatever's left over is the market value. It's a relatively simple process. And it works. It generally works reasonably well, but it doesn't stop there being a lot of arguments about it, needless to say.
Yeah.
So Steve, or Mark, maybe your views that if you have, an expert undertaking such a kind of an exercise, how would you say that the exercise done by Niall is right, or you would put up some, challenge to such a kind of an exercise? Steve,
Yeah.
maybe you can start
Yeah,
and followed by
yeah,
Mark.
I'll go first, and Mark, I'll try to be short, Mark, and then you take it up. I think this is a trite answer, but it really depends in part on having good experts, and this is a very expert heavy exercise, so that's the starting point. But I do think the sort of netback process that Niall described, there are two complexities to that. One is that's not always how the clauses read, right? So in European clauses, traditionally you had often the trigger and then the adjustment would follow from this related to a significant change in the market or some sort of language like that, which then required there to be a formula adjustment that reflected that change. And so merely saying the value of LNG through a netback process is X doesn't always fully answer the question, combined with the fact that you may be arguing about what window of time you're looking at and other critical factors. In Asia, a lot of the contracts are benchmarked, so it's a comparison to prices in other designated markets, and you get that in Europe sometimes as well. But it depends a bit. There's a lot of complexity depending on how the clause reads. But I do think ultimately, and I want to come on to this later, the reason experts disagree is that the concepts might be straightforward, but the application can be quite difficult. And the clauses themselves can require you to take into account or argue about what properly should be taken into account in a lot of different ways. So if it was as simple as just feeding it to an expert, I think the process would not have led to so much litigation or dispute over the years. But having an experienced expert is critical.
Yeah, I would also add that the netback is a fairly common mean, but you can also do it by reference to other LNG prices or other gas contract prices. The difficulty with that, of course, is they're all confidential, and it's very hard to determine what the price is under these other contracts. And that's another way of doing it.
The problem is in Asian contracts, it's often explicitly what you have to do. It's not so simple. What's the value of LNG in this market? In a lot of Asian contracts, it's a comparison to identified other markets. And so you have to then wrestle with the lack of information.
Yeah, lack of information is a big problem.
Mark, what are your views on this?
Yes, thank you, Rohit. I generally agree with Stephen and Niall. From an Asian perspective, we tend not to use the netback method for determining a new price. But as Stephen indicated, usually the standard here is to set the price with reference to other comparable contracts, and usually comparable contracts into a certain market. So that market might be into Japan, it might be into Japan and Korea, could be China, depending on where the buyer is. But one has to have regard to those comparable contract prices. Niall is right. There's a real challenge with regards to getting access to information, and it's interesting how negotiators of these provisions from the 70s and 80s onwards have provided for a comparable contract analysis, even though confidentiality is very important to LNG contracts, and the participants hold dear to their heart the prices that are agreed. But notwithstanding that, there is a lot of pricing information available. There are dedicated databases, FGE and Potent, for instance, that purport to provide information as to what the comparable contract prices are in Asia into these various markets. And so often what you'll have is a debate not only about which contracts are comparable in terms of quality, the origin, security of supply, whether it's a brownfield project or a greenfield project, if it's a certain part of the world, and so forth, but also which database is reliable in determining the prices that you can be comparing to your contract price. And one of the tips that we have, back to your first question, Rohit, as to how to avoid litigation, is this negotiators are aware of this problem, so they can prescribe within the price review clause which databases or range of databases can be considered, or the mere fact that databases can be considered, and or whether or not the parties can have access to, or can utilize their own contracts. Some of the participants in these price reviews have large portfolios of contracts. Often you will see a provision within one of these price review clauses that says that those contracts can or cannot be considered in the price review. That's something that can be negotiated and agreed. But I think, through these mechanisms, there's bound to be debate, but those debates can be narrowed through careful drafting.
I just to pick up on Mark's point for a second, though, I think there's opportunity in Asia to revise clauses, particularly as the approach has changed. And as Mark was saying, a lot of the older clauses were very vague. Historically, it's been extraordinarily difficult to get repeat players to revise these clauses because they know the problems with them, but they're afraid of the unknown, and you get this attitude sometimes of, I know how this works badly, but at least I know how it works, and B, I can't persuade my counterparty to consider my more innovative approach to this because they're suspicious that I must have an ulterior motive, and therefore they'd rather stick with a modified cut and paste from the clauses we've been using for decades that don't work well. It's an issue, but I think the Asian experience is allowing us to be a bit more open-minded and be a bit more innovative in drafting clauses going forward. But it's really difficult in Europe in particular to get people to change clauses that everyone knows could be better.
Yeah. And Rohit, I might just add one point that's topical, which is, of course, what's been happening in the Strait of Hormuz. And even though we understand that progress has been made in recent days, when you are, and I might just pose this as a question, as much for Niall and you, Rohit, but it is a question that's coming up in price reviews today, which is that if you are to undertake a comparable contract analysis, how do you treat contracts that now are currently not delivering because of the current conflict? And if you would have a price review today, and at this point you're considering contracts delivering from Qatar, for instance, that have not been delivering for the last 4 months, and there's no real visibility at this point as to exactly when those contracts will start to flow, there is a real debate as to whether those contracts can be considered to be comparable to others that are flowing. And a question is, for how long do one of these projects have to be blocked before you exclude it? Or do you apply some sort of discount because of the fact that it's currently blocked and there's visibility as we sit here today, with the parties having signed the MOU, that perhaps those contracts will start to flow again soon, other than those that are coming from projects that were actually destroyed. I think there's a really interesting question there as to how much weight, if any, you can put on those contracts in current price reviews that have been conducted under a comparable contract analysis.
That's a very interesting question. My inclination is that even though deliveries may have been suspended, the price still exists. The price is still valid. It was agreed independently between two parties. My feeling is it probably should be included, but it's, as you say, it's a subject of legitimate debate. Hopefully.
Sorry, Niall. Yeah, please.
Yeah, go on.
So that is precisely my next question, which I was about to ask, that in light of what is happening, the Gulf issues and all those things, there is a time period or a window which needs to be considered when you are doing, your verification of the prices or coming out with the what could be the right prices, Nile. So, question to you, Nile. So, how do you avoid cherry picking a favorable period when you are comparing a comparable contract or using a comparable contract?
Well, cherry picking is not necessarily a bad thing. It gives you a better price, isn't it? So I wouldn't necessarily say wouldn't necessarily condemn cherry picking. Um, it's not easy to do because obviously, if you look at the data and you establish a particular period that's favourable to your case, whether you're a buyer or a seller, the other side can read the data just as well as you can, and it's probably going to be quite hard to achieve a particular cherry-picked period. The general principle in doing pricing is that if you have a price which relates to the first day of the contract, and you have a period that you use for the base period, there's a price you use to calculate the price in future, the relationship between that start date and the base period should then be replicated when you calculate the price in future and the price data you use at that point. Because what you're trying to do is to get the level of change in indicators over a period of time, not too much, not too little. Well, let's say, for example, you have a contract where the first price is calculated, say the 1st of January 2027, and you're using the spot LNG prices for Q4 2026. Or when you calculate the price in future, you should be using the price from the previous 3 months. So the relationship is always the same. You always get the right amount of price increase or decrease, not too much and not too little. That's the theory anyway.
Steve, your views?
Yeah, I think the question of the time periods are really bound up in interpreting the clauses, and there is a lot of debate about what a clause means. A lot of clauses will say recent for when you're talking about comparable prices, and we're talking about Asian contracts. And Mark's explained the benchmark to other comparable contracts. A lot of times they'll talk about recent, and then you have a lot of debate about what recent means, and therefore it's not cherry picking. It's ideally coming up with a reasoned and persuasive basis to use a particular time period. There is a lot of concern that you don't take something that is a sudden spike or move in a short period of time and use that as a basis to fundamentally shift the price going forward. And there'll be a lot of argument about whether either a definition of recent or a certain period of time is artificial. And there's also debates in some clauses or in some arbitrations because of the delay between when the arbitrators are sitting and the time periods being looked at, whether we should look at what happened after the dates that are being used to do a reality check. So you get these complexities. But I do think it's about it's having a good expert with a good contractual definition to justify looking at a particular time period.
I think it's probably a good idea to have a defined time period because we just say recent. That invites considerable argument.
But that's what the clauses say. Again, it's going to be a long time before those clauses change.
Mark, would you like to add something to this discussion?
Yes, I think one can draw a distinction between older contracts that are broadly worded that don't prescribe solutions to much of what we're discussing today, where there's perhaps greater scope for cherry picking, as you put it, Rohit, because of that lack of specificity as to exactly what the parties should be focusing upon. Some of those contracts have price review clauses that are only half a page long, but more modern price review clauses, and perhaps it's a misnomer calling them clauses because they can span many pages, 3 or 4 pages, and that narrows the ability to cherry pick, as it were, because prescriptions are given for much of what we're discussing, including as to what is the cutoff point, which is often an important consideration in these price reviews. You can consider information in the review up until what point, and Stephen was just suggesting perhaps there might be an argument you could consider information even after that point in the context of the arbitration. But I think, Stephen, you were suggesting as more of a sense check, as a reality check, than one actually allowing this information to be directly considered. And I think there are debates about that, even whether you can even use it as a sense check, as a matter of English law, for instance. If you do have a a cutoff point either prescribed by the contract or as determined by a tribunal, there's a real question as to whether or not you can be considering information after that. But you can see just from recent events how significant these cutoff points can be as prescribed in a contract. If you had a contract that said you are to consider prices up until 28 February 2026, so the end of that month, as compared to one that said consider prices up until the end of March 2026, commodity prices were very different during that period of time. Admittedly, that spike that we saw in commodity prices will be evened out because you're not just looking at 1 month of data in your price review, you're looking at extended periods of time, and so there'll be an evening out effect. But nonetheless, a change of cutoff date from 1 month or more could have a significant impact on a price review, and the parties may be stuck with that because of the express language of the contract, or that's what the applicable law ultimately leads a tribunal to determine is correct.
I don't want to go on this because it's so technical, but in Mark's example, one question is going to be if you're identifying a period of time, say a 3-year window, and you're looking at comparable prices in that 3-year window, there are some clauses that might be interpreted to say what is the value of LNG as of the last date of that period versus what was it over the course of that period, and that leads to very different approaches economically and in terms of evidence. And again, this cherry picking argument still might apply in the sense if someone says, look, prices spiked because of a short-term event at the end of this period, and that shouldn't be something that drives prices going forward because it's a spike, right? So you can see the arguments that start to develop. We'll leave it there because I think we've got a lot of other interesting things to talk about.
Well, Stephen, I might just pick up on that because your comment there sort of suggests that there are black swan events, and there are. But for me, and interested in everyone's views, we're actually at a point now where we have a flock of black swan events because they are happening continuously, whether it's Fukushima, whether it's the invasion of Ukraine, COVID, of course, now with the blockage of the Strait of Hormuz. Volatility is almost the only constant in recent years. And how do you account for that constant change? And I think, Rohit, many of the people that have joined this call might be surprised to learn that in these price reviews, there can be a real debate about whether or not you are looking at prices in the rearview mirror or looking at projections into the future in one of these reviews. Some contracts are prescriptive on that. Many of the older generation price review clauses in operation in Asia are not. And you can actually have what's interesting in that regard is you can have a backward-looking price review conducted during the first and second price review, but then in the third price review, as forward curves have become more liquid and reliable, arguments solidifying that you should be looking at forward-looking prices in your price review, which Stephen, if that's the case, might eliminate somewhat the backward-looking black swan events that have already happened. Although there's an argument, which Niall and others could comment upon, that those forward projections themselves are being affected by the rearview-looking black swan events, that they're actually having a continuing effect on forward curves. All rich topics for debate.
The advantage of looking backwards is always that it's actual prices. These things have actually happened. If you're looking forward, you don't know. Forward curves are still relatively unreliable. They don't trade much beyond about the first few months, and they can shift around dramatically over time. So it's kind of a dangerous way to go, try and look forward, I always think.
Look, this is a much longer conversation, and I think actually some of the questions we're getting, this is worth clarifying this. These are long-term contracts. There are not a lot of negotiations that are being based on short-term events like the Straits of Hormuz or things like that. Parties who are entering into either price reviews or particularly entering into negotiations for new contracts are not making short-term decisions about the language of these contracts right now. They're thinking over the course of decades for these contracts. Mark's point about black swan events, I don't think anyone can say that these are black swan events. The whole history of modern LNG and pipeline gas supply has been affected by huge supply and demand shocks, as well as huge regulatory changes. I mean, the genesis of the waves of price reviews in Europe was the deregulation of the gas markets in Europe, and that's what the rise of gas markets, right, which changed the historical reliance on petroleum prices, and that was what led to a huge wave of price reviews in Europe because the whole market changed in the way it was regulated and run, and competition was introduced. We had markets in Fukushima, we had the Ukrainian war, we had a global economic crisis, we had the rise of shale gas, we had lots of gas coming into Europe. We had shortfalls. The price reviews we've seen over the last 20 years have been driven by huge supply demand shocks. And these clauses were originally not about supply demand shocks. They were more about regulatory and fundamental changes. That's what they were written for. That's why the European clauses talk about significant changes. They were thinking long-term structural changes. So when we think about these things, it's hard to say that we've got black swan events because there'd be a whole flock of black swans to be pointing to, right? So it does though mean that when you're thinking about what events to consider, you're looking both at other long-term contracts when you have benchmark clauses, right? So when in Asia, you're looking at other long-term contracts that are not shifting suddenly because of short-term events. They're locked in, and they may be undergoing periodic price reviews themselves, but they're not these short-term events are not changing the terms of contracts short-term, right? So we need to keep this in mind. These are buyers and sellers who are thinking long-term and reacting long-term, but in a industry where there have been massive changes, both in the rise of the use of LNG and gas over the last 30 years, and then these big events that have changed how the value of gas can be calculated because of deregulation, introduction of competition, and then these big supply and demand shocks. And Fukushima was as big or bigger than anything that the Russian war created, or I think likely the Straits of Hormuz, which are both, I think, much shorter term and much less of a lasting economic impact on pricing the way the Fukushima did, right? And so let's put it in that context.
I think, yeah, that's a wonderful, discussion. So that brings me to my next question. In light of all these so-called black swan events, you have either categorized as beyond the control of the parties or economic hardship or force majeure. So, in light of the, provisions of the contract which are there in all these long-term contracts, what weightage does tribunal give to, things which are beyond the control of the parties? It could be either because of the force majeure or economic hardship and all those things. So what has been your experience, Mark, on such black swan events and how the tribunal is handling such kind of things?
Thank you, Rohit. Well, I think the most recent situation is a good vehicle to consider that question. So the blockage of the Strait of Hormuz and whether or not that's given rise to valid force majeure claims, and the short answer is yes. And many of these long-term supply agreements have take-or-pay provisions that require the buyer to take, failing which to pay. But of course, that a clear exception to that obligation is if they can't perform, if they cannot physically take it because of a blockage, then prima facie there would be a valid claim for a force majeure. Many of the force majeure clauses that are in operation expressly refer to acts of war and blockade, of course. I think going forward, they might also refer to acts of Trump as qualifying as force majeure events. Just like post-COVID, we started to see a lot more references to pandemics in force majeure clauses. I think we might start seeing references potentially to Trumpian acts also, or how he might put it, acts of God. Could well qualify. If that's he probably thinks he automatically qualifies already under that description. But seriously, so yes, I think there's a clear case for force majeure for those that are directly affected by the blockage. It becomes more debatable the further down the supply chain you go. So here in Asia, if you're looking at second, third levels down from the immediate buying obligation, then there can be debates about whether or not they have been sufficiently affected by what's happening in the Strait of Hormuz to justify a force majeure. Notwithstanding that, we have seen a whole cascade of force majeure declarations throughout Asia, and primarily, I think, from those that have direct supply obligations or supply rights from that region. And I might also add, in the context of LNG contracts, that often you have this concept of force majeure deficiencies, whereby if there is a declared force majeure, the seller over time is under an obligation to try to make up for the deliveries that were not provided. And they have to make that up in future years. And I think we're going to see that playing out over the next couple of years as sellers seek to make up for those deficiencies. And there'll be debates about whether or not they're doing it quickly enough, whether they should be doing on a pro rata basis or prioritizing certain buyers over others. And another issue that's going to be debated, and I think already is whether or not sellers can be using sources of supply other than those that are blocked by the Strait of Hormuz. Some contracts for the sale of LNG are specific to projects. Some are even more specific to particular trains. So in Qatar, there were 2 trains that were destroyed, trains 4 and 6. There are some contracts, and I can actually identify them for you through public records, that where there are buyers that have contracts of supply related to those specific trains that have been destroyed. Clearly, there's a valid force majeure in relation to those. But where there's a project supply base that can be used, and some other trains are not being damaged, is there an expectation that the seller will still deliver from other trains? Or more broadly, some of these contracts are portfolio supply agreements. So even if they're blocked in the Strait of Hormuz, they could be using sources of supply elsewhere. And so buyers will be claiming that that the seller in that situation cannot be claiming force majeure because they have options elsewhere in their network to be making up for the deliveries. To which the seller will say, well, they've only got so much supply, and they've got they have to prorata what they have across all of their buyers. But I think there's real debates about whether or not that's being done correctly, and whether there should be some sort of redress for buyers that are not receiving their full allocation.
Yeah, you allude to a very, very thorny topic about whether if the source that you had planned to use to supply a customer has been damaged or is blocked in some way, should you use other sources? And it's something that I've had experience of, and that suppliers are generally very unwilling to accept that kind of obligation. Not impossible, but they tend to duck it, even though they may have a portfolio, as you rightly say, but the portfolio is maybe allocated elsewhere. And it's a very, very difficult issue, this. And one that's...
Yeah, so Steve, I think... Thank you, Niall. Thank you, Mark. So, Steve, I think this is my point of next question, which is quite relevant because of this recent Strait of Hormuz issues. Suppose if a buyer who cannot physically receive, cargoes because of this blockade and other issues and all, and in such a situation, what happens to the take or pay obligations? A seller who cannot deliver, can he escape from its supply commitment under some clauses which you have seen in such kind of long-term, pricing contracts and all? What has been your experience in that area, Steve?
Yeah, my experience is that we don't know how this will play out yet. There have been force majeure notices, but we don't know what the consequence will be. Most of these long-term take or pay contracts, as Mark explained, have provisions for if there's undersupply during a particular annual contract year. It requires then the seller to provide makeup gas the next year. When you have a force majeure that's accepted or claimed, and you suspend delivery or take obligations, there's going to be a number of consequences in terms of trying to figure out how that fits into these contracts that have very sophisticated clauses about under supply or ranges and some flexibility about annual contract supply amounts. And so we don't know yet how this will play out. Partly also because we don't know how, other than, as Mark pointed out, the destruction of the trains in Qatar, we don't know how much of an effect this will have on gas supply given alternative supplies, and whether the months that this has lasted will lead to big supply disruptions that will not be made up in a way that can't be handled commercially between the parties. And I would emphasize, as with the pandemic, I think a lot of parties will come to commercial resolutions of this. including by looking at value they may have been able to gain through price arbitrage opportunities and the like, and how they might share that. So I think this is a lot still to see, and these contracts are really sophisticated, and whether the events will be accepted as force majeure and what the consequences will be in these very complex contracts that schedule supply over a number of years and supply obligation over a number of years. I just think it's hard to tell. Out of the pandemic, we had lots of force majeure notices and actually a fair amount of reasonable resolutions between parties that didn't lead to litigation or arbitration. And that may be how this plays out for many, many parties. But where you have a fundamental disruption and an inability to replace needed supply, it's going to probably turn into very high value, high stakes disputes.
So, Nile, in such an instance where the take or pay obligations cannot be fulfilled, how you as a quantum expert or valuing such kind of damages, how would you work out the quantum for such kind of
Well,
damages?
it all depends on the exact contract wording, but generally, if you are a supplier that's unable to supply and you've claimed force majeure, that amount will be deducted from the take or pay obligation on the part of the buyer. But as I said, the obligation on the supplier to supply in the event that the planned source is blocked in some way depends a great deal on the wording of the contract. It may be that it's tied, as Mark says, to an individual train, to an individual LNG plant, in which case the obligation to supply further is probably very, very limited. If it's a more general supply obligation, then yeah, the supplier will be obliged to find another cargo from somewhere else from its portfolio. So it depends a great deal on the wording of the individual contract. They vary quite a lot in my experience. But I would say that
let me just
getting a
yeah.
general supply obligation is tough to get out of suppliers.
Let me just reemphasize, though, that I think there'll be a lot of commercial solutions. I mean, and these
Yeah,
long-term
absolutely.
contracts, and there's a lot of value that was gained and may be lost. And I think a lot of parties will sit down and make sophisticated calculations about how to resolve this stuff rather than wanting to get caught up in huge arbitrations on ongoing, long-standing supply agreements.
Yeah, but it may well be that the threat of arbitration is what compels parties to reach agreement. Our experience in price reviews is that even once they're initiated, probably only about a quarter of them actually go through to the hearing, and 3/4 of them are settled.
And these issues aren't really price review issues; they're broader contractual issues. And so,
Yeah, the same principle applies then.
yeah, no, but the dynamic will be a little bit different, particularly in Asia, I think. But where the embrace of arbitration in those clauses is the fully using all the contractual options is a newer thing. And Mark pointed out why sometimes for price reviews it's an uncertain thing because it's not clear you can actually go to arbitration under some Asian contracts. But I think let's watch this space. I think any predictions we make today, we will regret. But
So, Mark, based on your experience of arguing such kind of cases in front of the tribunal, how do you see a tribunal will react or view issue of force majeure versus economic hardship versus beyond the control of the parties? And specifically, we are talking of a situation where the take or pay clause cannot be respected, like the example which you gave for Qatar LNG trains and all. So, in which direction do you think the tribunal will probably go in such kind of instances?
Well, in the direction that the contract points, ultimately, under the common law, force majeure claims are subject to the precise terms of the contract. I know that many civil law systems have a codified version of force majeure, but it's the contract ultimately that will determine whether or not a party can rely upon it. And as I said earlier, I think the degree of remoteness from these events, those that are directly affected, they will have very strong claims of force majeure. Those further down the value chain, there's greater scope for debate, principally because they might have access to other sources of supply. And so their ability to argue that they are constrained by recent events reduces the further away contractually and to a degree physically they are away from the Strait of Hormuz. There's another topic I wouldn't mind talking about, Rohit, which is how the profit or cost that can be generated by these events should be shared between the parties. Should I perhaps talk about that briefly?
Yeah, that's a lovely issue, and that's the point of our next discussion. Please, please.
Because, and I wanted, if you don't mind, I might just share a screen for our audience that could help illuminate this, which they might find interesting. Can you see this chart showing prices?
Yes, it's quite clear.
Okay, wonderful. So let's imagine a situation where you've got an oil-linked SPA, and I guess you can see my cursor as well.
Yep.
Yep.
Yes.
Yes.
So you've got an oil-linked SPA, and the price is here. And if the seller fails to deliver because of the recent events, and this is February, March, so this is affected by the events in the Strait of Hormuz. If the seller failed to deliver, then the buyer could often claim the price under the SPA plus liquidated damages, and liquidated damages is often set at plus 30%. So they might get to there. But what happens if the price that the buyer has to pay when it enters the market to replace the cargo that it hasn't received? What if the price is up here? And so it may be limited to getting a contractual remedy to there, the contract price plus 30%, but its losses are up to here, potentially, if it's actually entered into the market to buy replacement cargoes. So the first question is, can they break through the liquidated damages barrier? And often the answer will be yes, if there's been, again, subject to the terms of the contract and the applicable law, but if there's been willful breach, if the seller has deliberately breached the contract to take advantage of these elevated prices, which arguably we saw with the Venture Global situation, and I think, Stephen, you might be talking about that briefly if time permits. So let's imagine that the buyer can smash through the liquidated damages barrier because they've been able to establish willful breach. And that's not hypothetical because tribunals in recent times have actually found this. Can the buyer claim this amount for its replacement cargo? And I think the answer is probably yes. But let's imagine a situation, and this is where I think this gets really interesting. Imagine a seller breaches the contract about here. It then sells the dedicated cargo at this price, which is very elevated. And the buyer, when buying a replacement cargo, buys a cargo here. So its loss is there, which it could recover if it's been able to break through the liquidated damages claim. There's a question, I think, for our panel: who gets to keep this profit? So the seller sold it then, the buyer bought the replacement cargo then. Does the seller get to keep this profit, or can it be disgorged? And what I would suggest, and I'll take that down, is that the seller does get to keep that profit under the theory of efficient breach, which has been recognized in many states in the United States, and it's also been recognized in English law in recent times, which the theory is that the broader society benefits if a party in breach can optimize its return by going out into the market and maximizing that return, and the non-breaching party can recover a remedy that puts it, makes it whole. So its expectation loss is recovered. It's made whole. Does the breaching party get the profit on top of having made that non-breaching party whole? And under this theory of efficient breach, the answer is the seller or the breaching party does get to keep that profit. And I think that could be an interesting issue that gets debated in these cases going forward. Given the volatility that we're seeing in prices, there will be times when the buyer is actually obtaining replacement cargoes at a price lower than what the seller has been able to obtain when maximizing its profit. And somewhat provocatively, I would suggest that the willfully breaching party in that situation, under the theory of efficient breach, gets to keep its profit.
So, Steve,
that's interesting, Mark, yes, but not relevant in the case of the Strait of Hormuz, because Venture Global, the guy sold the cargoes elsewhere, that would apply there. But in the Strait of Hormuz, the cargoes couldn't be delivered. There was no question of sharing out a profit. There was no profit.
No, that's true. But these prices that I showed, they applied across the market. So parties could have not affected by the Strait of Hormuz, like even in the US or here in Asia, their sources of supply from Australia, from Papua New Guinea, and elsewhere. They could have benefited from these prices by deliberately not delivering in order to maximize the prices they could get in the spot market. Do they get to keep this rump, this profit, or can the non-breaching party disgorge those profits? And it's something we can debate, but I can tell you that there's English law support recognizing the theory that's long been recognized in the United States that that as long as the non-defaulting party is made whole, that its losses have been made up, the willfully breaching party can retain any windfall profits on top of that.
I'll leave it with Mark's point because I think this is to be seen, but I would say that there's also going to be arguments about what legal basis was used to breach and what the consequences are of that. And many contracts do have profit sharing mechanisms in them, particularly
Yes.
about sales of cargoes to other destinations, et cetera, et cetera. So it will be again, the boring legal answer will be it will depend on what the contracts say and what legal theories. But I do think this is likely to be something that will also be subject to commercial discussions, right? Because a lot of these disputes, and I've been involved in a number of them, in which the parties ultimately decide to figure out a way to share benefits in order to avoid a long fight. And so and again, these are not one-off transactions. These are contractual relationships that last for decades. And I think despite the explosion in price reviews, I think there's also a lot of interest and history and many of these parties have in ultimately solving some of these problems. And I know I keep saying that and it's boring because we all want to hear about litigation and arbitrations, but this is a special type of contract and a special type of contractual relationship which affects the way people behave. And then historically, it's dampened down price reviews in Asia, I think, unnecessarily, into the negative interest of some buyers. But it also is something that ultimately is a relationship, and it affects how people will deal with some of these price arbitrage and other opportunities.
So, Mark, over here, what is your view on the concept of efficient breach? Would you just say that it depends upon the contract and the governing law, or do you have something else to add to it?
This is being recorded, Mark.
So you're asking me?
Yeah.
Well, no, I think it does depend on the applicable law, but this is a theory that's taken hold within the United States. That you can there are many courts within the US that have recognized this, and interestingly, you would not expect it to necessarily have been embraced within England, but it has. Starting with the case of Attorney General versus Blake, which dealt with facts very different to what we're discussing now. But within that judgment, there is a recognition of this theory, as well as a Supreme Court decision of last year, where one of the lords recognized and used the word efficient breach in their analysis. So I think there is a good argument, well, at least there's a developing argument that can be made that the willfully breaching party gets to keep, just to sum it all up, the willfully breaching party gets to keep their windfall gain as long as the innocent party, the non-breaching party, is made whole. And in highly volatile markets like we're seeing, and like the venture global cases demonstrate, this behavior can happen. And Steve makes a great point about how contracts can regulate this issue. And for those that are listening to your seminar, Rohit, that are involved in the negotiation and drafting of these provisions going forward, they may want to prescribe for this. They may want to say something that perhaps they never thought wouldn't be necessary in the past, but actually expressly states that any diversions, any profits that are gained following a diversion are to be shared. To Stephen's point, interestingly, that then raises questions as to whether or not that's an unenforceable penalty, because by definition, the innocent party is gaining a remedy beyond its loss if it's actually sharing in the windfall gain of the breaching party. And is that a penalty? I think there's debates to be had about that. But But I think it's going to be fun, Rohit, seeing this play out in some of these cases potentially.
So great. Thank you, Mark. Thank you. It's really, lovely discussion. So just we have another 1 or 2 minutes remaining. So Niall, over to you. One line conclusion on your views on disputes of LNG and gas pricing contracts in today's world.
You have to have a price review. I've outlined in my response to you all the different indicators you can use to calculate price. But over a 20-year contract, you can't guarantee any of them will work properly. Price reviews are inevitable. They're messy, they're expensive, and they're difficult. But it's hard to avoid getting massively out of market without them.
Thank you, Steve.
Yeah, if you indulge me, 2 points. I do think careful use of experts, including I'm putting my arbitrator hat on now. The way experts present and the way experts are used, including post-hearing, is essential to avoid some of the confusion that arises under these very economically heavy and complex disputes. And the other thing I would say is we were already seeing a wave of price reviews in Asia. It was not necessarily where Europe has been, but it's moving in that direction with having nothing to do with either the Russian war or the Strait of Hormuz. This will, I think, accelerate though the use of formal price review mechanisms and actual disputes, arbitrations, and expert determinations for Asian supply
the key is
contracts.
to make sure that
And we may see a
one
situation
side.
where it just becomes built in.
Mark.
The key in Asia, I think, is you have binding arbitration. And if parties can't agree, it goes to arbitration. That's it.
Yeah. Thank you, Rohit. I think to echo what I said earlier about the need for when parties are drafting price review clauses and indeed long-term contracts generally, to try to get the balance right between certainty to focus the minds in a future price review and flexibility to account for an uncertain future. It's extremely difficult to get that balance right. I empathize with the drafters of these provisions, and we can understand why up until recently they kept those clauses very general and very broad. So I think that's the first point to try to get that balance right. And then secondly, whether you're talking about a force majeure claim or a price review, and I know this is trite, but the need for careful preparation, use of experts, use of counsel, both in-house and external, to get the strategy right early, so that you can present the best possible case, including potentially the need for some creativity, both from the experts and from counsel, when dealing with these very interesting evolving events, and considering them through the prism of the contract. You need careful preparation and, to a degree, some creativity.
Thank you, Mark. I think I have a number of questions, but because of the shortage of time, probably I'll leave the questions, and the attendees are quite free to contact the panelist or to us, and we'll be happy to answer your questions. But at this stage, I'm really, really grateful to Niall, Steve, and Mark for your great discussion and giving your practical and insights on the issues of disputes related to gas pricing long-term contracts. And I'm also thankful to all the attendees for attending our webinar. The recordings of this webinar will soon be shared with each one of you, and we'll be quite happy to take up on one-on-one basis, or you can send it to us, your questions and all. Thank you very much. Thank you, everyone, and thank you all. Thank you.
Yes,
Thank you,
Rohit.
Thank you all so much, and have a lovely day. We'll send out a recording in the coming days. Thank you all. Bye.
Thank you.
Thank you. Bye.
Bye-bye.